like a band director, making sure everybody's got their instruments ready. Okay. The next case is Klein versus Iowa Public Information Board and others. I believe Ms. Austen is arguing for Mr. Klein. Is that correct? And then I want to make sure I've got it correct. Emily Willits is with Iowa Public Information Board and Holly Corkery with Burlington Police Department. Who's going to go first?
Your Honor, I'll be presenting first.
No, I mean those two, Emily and Holly.
Your Honor, I will be going first on behalf of the Public Information Board.
Okay, I'll let the two of you then decide how you're going to divide your time. Okay, thank you. Ms. Austen, you may begin.
Thank you, Madam Chief Justice, and may it please the court, counsel. In the recent Mitchell case and in many cases before that, this court has recognized the vitally important role that access to public records plays in our democracy. The purpose of Chapter 22 is to open the doors of government to public scrutiny and prevent the government from secreting its decision-making from the public. In recognition of this vital function, in 2012, the General Assembly created the Iowa Public Information Board with the express purpose of providing a low-cost, efficient, informal process to resolve public records disputes as an alternative to hiring a lawyer and filing a mandamus action in court. This case presents a threshold question about whether the Public Information Board will fulfill this important legislative purpose, or if appellees prevail, whether it will become an inefficient, expensive, procedurally complex bottleneck that only serves to delay access to records and complicate access to records and the resolution of disputes for those who file a complaint with the board rather than go to court. And this case exemplifies that. It has been 6 years since Ms. Steele was tragically killed by a police officer, and her attorney, Mr. Klein, filed a public records request for records related to that shooting, was denied, and then within the statutory period filed a complaint with the Public Information Board. The district court's dismissal of Klein's judicial review petition was reversible error in 3 ways.
I agree with where you're generally coming from, that I think this thing needs to be workable, and I think that's probably what the legislature would have wanted. Can your client bring an action now under 2210, or is that off the table?
Your Honor, I believe when you look at the choice of remedies provision in 23.5, that it is now off the table entirely, that members of the public have a choice of remedies. They may either file a complaint with the Public Information Board, or they can pursue a mandamus action in court. But it talks about those as being in the alternative to one another. And so once you choose a course, you're really locked into that course. And that goes to the decision-making here and Mr. Klein doing everything he needed to preserve his interests, because another piece of that choice of remedies provision in 23.5 says that when there are multiple parties who have been denied access to the same public record, and one files an action in district court and another files a complaint with the board, that the district court action is stayed until the board has completed whatever it's going to do on the complaint. And so in this case, Hawkeye, which is the newspaper that covers the local events in Burlington, had already filed a Public Information Board complaint. And so by doing that, had Mr. Klein filed an action in district court, it would have been stayed for the entire period. And that, of course, meant waiting a very long time. In this case, it would have been, we're on 6 years now, before that was resolved.
And then the Public Information Board issues a ruling. Would that ruling then be res judicata?
Well, I don't think that the district court in a separate case, had that occurred, I don't think that the district court would show deference to the Public Information Board in construing Chapter 22. And this really gets to some of the merits arguments that unfortunately we're not able to get to because of the way that this case was dismissed. But when you look at the basis under Renda for showing deference to an agency for its construction of statutory terms, you look at whether it has special expertise on those, whether the terms have independent meaning outside of that area of the agency's expertise. And I think here, when you look at the fact that the Public Information Board was created in 2012 and this court's jurisprudence construing Chapter 22 long precedes that, I just don't think that you can say that it has that special expertise. But I also think, if we look at the merits of this case, the Public Information Board got it wrong. Mitchell makes that very clear, and actually Hawkeye made that clear, and Shanahan made that clear. And so...
there seems to be some dispute as to what was actually decided by the Public Information Board. So the board and the city of Burlington make it sound like it was just about the dash cam, the body cam, and the 911 calls. Is there anything else that was decided?
Is incorrect. So if you look at appendix, I think it's 2144, that is right. That is the Public Information Board's final decision, and the board itself talks about the crux of the issue being the body cam, the dash cam, the 911 calls, and the immediate facts and circumstances of the shooting. And so by its own terms, the Public Information Board was adjudicating everything that's at issue at our judicial review petition, which are those immediate facts and circumstances. And so it was shortly after we filed the petition for judicial review in this case that this court decided Mitchell, and that foreclosed the question about whether an investigation ceases to be confidential when no longer ongoing. And so really the fighting issue is just as to those immediate facts and circumstances records, but those go beyond just body cam, dash cam, and the 911 calls.
Reasons the district court should be reversed, and maybe you've covered some of those, but what are your 3 reasons?
So first, the district court erred in finding that Mr. Klein was required to intervene in the agency's contested case of his complaint, in which it rendered final agency action on his complaint. And the second reason is that it found that declaratory relief was unavailable in judicial review actions. Declaratory relief is expressly provided for in 17A 1910, so it's clearly available. And then the third reason really goes to Justice Mansfield's question, which is that the district court improperly narrowed the scope of the records that were at issue to just the body cam, the dash cam, and the 911 calls.
Those 3 issues would you have standing?
We absolutely have standing in this case. So, yes, we absolutely do. So when you look at what makes a person aggrieved under Chapter 22, it's the denial of the right to possess public records and the denial of the right to distribute those public records. And so in this case, the appellees make an argument that because of the separate federal civil rights case, which involved discovery, and during that discovery, many records were turned over to Mr. Klein in his capacity as attorney for Autumn Steele's family. They're saying that that moots his right to these records under Chapter 22, but that's simply not the law. Chapter 22 protects both the right to possess and also the right to distribute public records, and that's clear. I mean, it's expressed in the statute in 22.2, but it's also clear at the interest that this court has said over and over and over again that Chapter 22 protects, because there is no vital role in democracy in opening the doors of government to public scrutiny unless you can really share what it is that you're finding when you open those doors.
Those records, which records is your client not able to share or disseminate?
I apologize for what is a sort of complicated answer. I'm limited by the fact that there is a protective order. So what we do in the brief.
Are the dash cam, body cam, and 911 records all subject to the protective order, or does your client have access to them outside of his receipt of them within discovery in the federal case?
Thank you, Your Honor. So the body camera footage has been released to the public through the unsealing of some of the summary judgment records in the federal civil rights case. So those are able to be distributed. That is also true of a single 911 call. The record in front of the agency refers to multiple 911 calls, so any 911 calls that are not that 911 call that's been released, he would not have the ability to distribute if he had it. And that's also true of the dash cam footage. There's no dispute about that has not been released at any time, and it hasn't been unsealed. But I would just say that we also point to numerous publicly filed documents that we can point to that show that there was, in the exchange as part of discovery in that federal civil rights case, numerous other records which would fit that immediate facts and circumstances definition if you look at the Mitchell case and the Hawkeye case.
I think we said there was sort of, the trial court had a time limit. If it was like the first 4 days, then it's immediate facts and circumstances. And, you know, we thought that was good enough. It was a pretty good idea by Judge Grady. And so you're saying there's records that are in that category.
That's right. What we're asking for here is for the court to reverse on these improper procedural findings and remand so that the district court can engage in that Hawkeye balancing test. So I don't think that this court has to decide yet in this case, you know, what are immediate facts and circumstances? Is the line 96 hours? Is it potentially case by case?
But here's what if we agree with your general proposition that Mr. Klein didn't have to intervene in order to have standing to seek judicial review, it does seem to me it's a little unfair if he would now come in and say, well, the board should have considered this and this and this and this and this, and he had an opportunity to intervene. Isn't it fair to say he's stuck with the record and the arguments that were made before the board? He can't, you know, kind of try and change the path of the case on judicial review?
Honor's point, and I think if you look at an analogous agency, which is the Civil Rights Commission, that generally is right. So intervention is permissive, it's not mandatory, but if you don't intervene, and it's a little different because you have a right to sue, and most people, if they have a lawyer, they're going to get that right to sue letter, but if they leave it in front of the commission, certainly they have a right of judicial review. They're treated as a party. That should be what this court finds about the Public Information Board too, but then they're limited to the matters that were decided by the ALJ and adopted by the commission in the contested case. I just would say here, though, that we're not challenging anything that former Justice McCormick did as special prosecutor. We think that he went about prosecuting this complaint perfectly well, and we're not asking for any form of relief that he didn't pursue in front of the agency. And so I take that point. I think if that were not the case, if Mr. Klein were unhappy with the relief that the prosecutor sought, then I think he would have had to have intervened to make arguments in pursuit of those forms of relief. But in this case, the special prosecutor was seeking all of the records that were the subject of Klein's complaint. And you know, the Public Information Board clearly adjudicated not just body cam, dash cam, and the 911 call, but also all of those immediate facts and circumstances, and they did so by their plain terms. I think the confusion comes in as I look at the district court's decision. I think the confusion comes in from the fact that at the time that former Justice McCormick was prosecuting this case for the Public Information Board, Mitchell had not yet been decided. And so he filed a motion to have the entire investigative report be decided. And the ALJ denied that. The Public Information Board accepted that part of the ALJ's proposed decision. But that's separate from the immediate facts and circumstances that the Public Information Board, by its own terms, in its own decision, if you look at App 2144, was deciding. And then the other point we make on this in our brief is just that, so hypothetically or arguendo, had the board intended to limit the records to just dash cam, body cam, and 911 call, if you ignore that and immediate facts and circumstances language in the opinion, then former Justice McCormick, in making the motion that he did and having that adjudicated, merely preserved error so that we can seek review of all of those records, and that can be part of the judicial review petition as well. And I see that I'm just out of time, so I look forward to answering this court's further questions during rebuttal. Thank you.
Thank you, Your Honor. May it please the court, counsel. I'm here today on behalf of the Iowa Public Information Board. And I'll just start by saying I think we are in agreement that this case was atypically long and complex. The board does play a very important role in helping to informally resolve some of these public records disputes before you ever get to this phase of having a contested case proceeding. The statistics, which I was just looking at, are, since the board was formed in 2012, the board has received almost 1,000 formal complaints. Of those, only 4 have proceeded to a contested case. The vast majority get resolved because the staff will reach out to the complainant and the records custodian and help to facilitate a resolution. And if you read through Chapter 23, that occurs before the board would ever make a probable cause determination to decide whether a violation of the law has occurred. But once the board gets to that probable cause stage and makes a probable cause determination, the proceeding takes on a more formal character. It is, the words in the statute are that the board shall appoint a prosecutor who will prosecute the case and decide whether any violations of the law have occurred. And the proceeding is a contested case proceeding, which is very much like a bench trial under 17A. And parties to the proceeding can make opening statements, they can call witnesses, they can cross-examine witnesses, they can make closing statements, and they can appeal. Intervention is very common in some categories of contested case proceedings. So, for instance, at the Iowa Utilities Board, you will routinely have interveners.
The issue isn't whether intervention would be appropriate. The issue is whether it was required to raise what was litigated before the agency, it strikes me. And what makes you think that it's required?
If you read the Fisher case, what's required is some assertion of party status. And, I've made the argument that Mr. Klein should have intervened because, to me, that's the most logical way to achieve party status in a case. The Fisher case, the court held that, the Attorney General's office in that case filed a motion for rehearing at the very end of the case, and in doing so, asserted its party status.
You describe it how it would work. I mean, the board is not going to appeal the board, right? I mean, so if you've made a complaint with the board and then the special prosecutor is appointed and you want to reserve the rights to go to court and ask a court to review or reserve any right to have a court review what the board did, then you need to intervene. So wouldn't you intervene in every case on the way you describe it?
Potentially, if you wanted to preserve that right. I will say it's also atypical to have an outside special prosecutor. So, yes, this prosecutor, because he was getting paid, would have needed the board's approval to proceed in the case. Typically, the board would use a staff attorney to prosecute these cases.
And the board isn't going to appeal the board.
I don't know whether, the board would require their staff attorney to seek consent or not, to be honest. It hasn't come up. I do want to say, had this case gone the other way, had the board adopted the ALJ's proposed order, Mr. Klein still would not have gotten most of what he's asking for here. But in that situation, he clearly could not have joined in the judicial review proceeding unless he was a party, because 17A, I believe it's subsection 16, says that if you want to participate in a judicial review proceeding, any party of record must file a motion to intervene in the district court. So that's why in this current judicial review proceeding, both Burlington and DCI filed motions to intervene at the district court stage, but 17A only allows them to do so because they were parties of record in the contested case. And so, the reverse also seems like it should be true. If you want to, be the appellant or the petitioner, you need to have somehow participated in the contested case proceeding. And Mr. Klein just simply wasn't a participant, although he did receive courtesy copies, I think, of everything. So he was certainly aware of what was going on. He was aware of the formal nature of the proceeding.
Have interpretive authority. I mean, the section 23.6 sub 2 empowers the board to adopt rules to interpret the code. So should we give, what's our standard of review, or what's your interpretation? You're saying under these circumstances, intervention was required for him to appeal.
Have interpretive authority with respect to Chapter 21 and Chapter 22. I don't know that that comes into play until you reach the merits of this case, which are not in front of you today.
You have interpretive authority over Chapter 23.
That's an interesting question. I guess I would argue probably yes. It relates to the board's duties and powers. There's not a lot of case law, obviously, because this board is so new, relatively. I want to talk about issue preservation for a minute, too, because Mr. Klein, in his petition for judicial review, seeks very broad relief that the special prosecutor did not seek in front of the agency. In addition to seeking all of these records that were not part of the contested case proceeding or discussed at the contested case proceeding, he's also seeking broad declaratory relief. And the way that he has framed it in his prayer for relief, and I do think he needs to be held to his pleading and the way he pled this case, is he seems to be asking for just a broad statement that body cam videos, 911 calls, dash cam videos are always public records. And that's not what was ever before.
Separate issues. So one is presumably the court, in exercising judicial review, if we were to send the case back, is going to consider some of these legal issues, right? But whether he can get a separate thing that we call a declaratory judgment, didn't we say in Sierra Club that you have to first ask for a declaratory order from the agency in order to get a that you can't, the courts don't declare declaratory judgments as to things within the agency's, kind of jurisdiction and authority unless you go to the agency first and ask for a declaratory order. So is there anybody who asked for a declaratory order in this case?
Declaratory order proceeding under 17A is an entirely separate category of proceeding from a contested case. It's also formal. The court held in the Store case way back in 1979 that you need to intervene and become a party to a declaratory order proceeding if you want to seek judicial review. I think what's maybe a little bit gray in this case is, the Public Information Board could order relief that is declaratory in nature, I suppose, in a particular case. They could say, well, we determined these records, this particular set of records to be public. I don't think that's the same as a formal declaratory order, but the relief, it accrues to kind of the public at large. So if the board decides that a particular set of records is public, not only does the complainant get them, but anybody that asks for them could then get them. And so that goes to our standing argument a little bit. I mean, I don't know that he has a specific injury in this case that's different than the public's injury at large to have access to these records. And under the court's analysis,
Just a little bit. The purpose of the public records statute is public disclosure, obviously. And so to have a document in your hand, but under a protective order, doesn't seem to satisfy the full scope of Chapter 22. Pushback.
so the argument we've made is that Mr. Klein has all of, well, I think many of the documents he's requesting. It seems like in his briefing he's saying there's maybe other documents that he did not get through discovery in the federal case, and he's raising that for the first time in this judicial review proceeding. But with respect to the three documents that were the three categories that were the focus of this contested case proceeding, which were really audiovisual documents, right? The body cam, the dash cam, the 911 calls. My understanding is he has all of that. The body cam footage that captured the actual incident is now public. It's available, on the internet. The 911 calls are public. I can't tell from the record whether there's more of those or not. I wasn't aware of that. And so, the dash cam video I believe just wasn't made part of the summary judgment record in the federal case, and that's the reason why it wasn't part of the court's order releasing it. If he were to prevail in this case, he could. Again, though, he wasn't a participant below, and that's the problem. And this is very wrapped up in some of these issue preservation cases, and I would point the court to a case, KFC, the Iowa Department of Revenue. That's a case that I know gets cited in, tax protests, where the court talked about the fact that you have to raise and preserve issues first at the agency, including filing a motion for rehearing if necessary to preserve them. Very similar to the preservation rules that we have in district court.
I left my thing. Let me ask you a question about this sort of issue preclusion, claim preclusion stuff. So let's say the judicial review proceeding ends one way or another. Or let's say it even goes and there's a ruling on the merits that some items need to be made public and some not. Is there anything preventing a different individual from going to district court under 2210 and asking for items that the board ruled were not discoverable and getting those same items by order of the court?
Facts. Well, Mr. Klein, I think he could have filed an original action in district court. The newspaper had already filed a complaint over with the board. So had he done that, his action would have been stayed while this case proceeded. But then presumably that stay gets lifted and the district court would have the benefit of whatever decision the board. Likely not, but it would be hopefully persuasive because the board does have interpretive authority and the legislature has identified them as an expert in this area. I do want to make sure to give Ms. Corkery some time. So with that, unless there are further questions, I would just ask the court to affirm the district court's dismissal of this petition. Thank you.
Good morning. May it please the court. My name is Holly Corkery, and I represent the city of Burlington in this matter. I want to try to address two issues in this very brief time, and the first thing I want to address is the arguments regarding scope here. Those arguments regarding what the scope of the case was and what Mr. Klein believes the scope of the case was, what the ALJ found, what the prosecutor filed in his petition, what the board ultimately upheld, those all could have been resolved had Mr. Klein intervened in the underlying matter. Mr. Klein could have dealt with those issues appropriately, we could have had discovery on those issues, and we wouldn't be trying to litigate them in front of the Supreme Court right now.
What is meant by the catch-all add-on that is in the record? They talk about the big three items, the dash cam, body cam, but then they say they also seek other records related to the immediate facts and circumstances. As I understand their argument, that's kind of a, kind of a categorical catch-all that would drag in other documents. What's your response to that?
My response would be to look at the record overall. And Ms. Willits just discussed this, but the contested case hearing, which I was at and participated in, focused on 3 sets of records.
This isn't going to do it for me. But I think the point's well taken. If you don't intervene, you're stuck with the record that was developed. You can't come, sashaying in a district court with, theory 4, theory 5, or whatever. I'm inclined to agree with that. And it may not have been the focus, but the question is, did they seek disclosure of additional documents beyond what I've called the big 3? And if they did, wasn't it preserved?
Through the catch-all, Your Honor. So to the extent that they would have sought those records through the catch-all, I think Mr. McCormick's motion to the administrative law judge that he filed just days before the hearing demonstrates the weight of that catch-all. At that point, Mr. McCormick filed a motion indicating that he was seeking the entire DCI file, and the record reflects that he stated he was changing his remedy. So at that point, I think that discredits any catch-all that was in his petition, because he then went to change his remedy for the entire DCI file, which would have been covered under that catch-all originally.
Question, Chief. I see the red light's on. You've read Mitchell. Why hasn't your client disclosed the dash cam?
Because my client remains bound by a federal protective order in the Southern District of Iowa with respect to the dash camera. I will note that is a stipulated protective order that Mr. Klein and his client stipulated to while this matter was going on in front of the IPIB.
I mean, it's your, the police, it's the police department's dash cam video. They can release it, can't they?
If we were to have that stipulated protective order lifted by Judge Gritzner in the Southern District of Iowa, then I agree we could release it.
Could you respond to opposing counsel's argument that if we require intervention in order to get judicial review, that we would undermine the purpose of Chapter 23 of providing informal dispute process?
Administrative rules are clear about intervention, and I think if we don't allow intervention, that prejudices parties like the city of Burlington, because now here we're litigating on things that were different than were in the contested case hearing, and dealing with a wider scope than what we had initially, disputed in the original contested case. I see that my time is done, and I thank you all for your time today.
Thank you, Your Honor. I would like to begin by just pointing out that Klein was indeed a party to the proceedings below, and if you look at the Storr case, which counsel cited, he meets that test. So Storr identifies 2 ways that a person might be a party. One is to be captioned as a party. The other is to participate in the proceedings, and Mr. Klein met both of those tests. He certainly was either a party or a person aggrieved, which is what 17A requires. He was captioned in the probable cause report. Obviously, it was his complaint that triggered the entire agency proceeding below. He filed a brief resisting the DCI's and Burlington Police Department's motion to dismiss his complaint. He was noticed throughout and treated as a party. The petition initiating the contested case filed by former Justice McCormick named Klein as a party. All of the minutes and agendas of the Public Information Board throughout the years that the matter was in front of the agency referred to it by his name, and Justice McCormick kept in regular contact with Mr. Klein throughout the process. And so we certainly argue that he was a party, but even if the court doesn't find that he was a party, he was a person aggrieved, and he certainly did participate below sufficiently to be able to seek the final agency action that was rendered on his complaint and which aggrieved him. He's met the criteria for standing because he doesn't have the right to distribute those records.
Like a party, but he's an attorney. He never actually filed a motion to intervene or anything, correct?
Need to. There's nothing, if you look at the test that this court has identified for when you need to exhaust an administrative remedy, it's first, does that remedy exist? Yes, there's a way to intervene here, just like in front of the Iowa Civil Rights Commission. But second, does the statute implicitly or expressly require that that be exhausted in order to pursue judicial review? And if you look at Chapter 23, you will see a lot about the complainant and the complaint and the contested case and the right to appeal final agency action on that complaint. You will not see any mention of intervention at all.
Question. A question was asked by Justice Mansfield about reading Mitchell and why isn't the dash cam released, and the response was a federal protective order. She said stipulated. Is that correct?
The protective order was stipulated, as they tend to be in these federal civil rights cases, but they are incorrect in arguing that the protective order binds the designator of the record. It doesn't. It binds the recipient to the terms of the protective order. And also, there is a co-respondent here, a co-appellee, which is DCI, which is not even a party to that protective order. Certainly, the board is not a party to that protective order. But in any case, the protective order only binds Mr. Klein. It doesn't bind the appellees in any way by its plain terms, and we've cited that in our brief. And then the last thing I wanted to discuss is this issue of declaratory relief and the difference between the Store case and the Sierra case and this case, which is that those cases are about a party, a petitioner seeking declaratory judgment and original action filed in district court without having first participating in the agency proceeding below. So if you look at the Store case, the court found that the landowners and taxpayers in that case that didn't participate in the underlying PERB proceeding were not able to seek a declaratory judgment on judicial review. There was no question that the county that was the initiating party before the agency below did have the ability to seek the declaratory judgment. And Mr. Klein in this case is like the county. He's not like the intervener, landowners, or taxpayers because this is his complaint. He's the one who initiated.
Order if you get the relief sought.
Seeking a declaratory order, Your Honor. He's seeking declaratory relief, which is expressly provided for in 17A as a form of relief in judicial review actions. And then on that, I have to make a critical point, which is that he sought declaratory relief below. In his complaint, he not only asked that the records be provided, but he asked that the Public Information Board decide that the records he was seeking were not confidential under 22.7.5.
Chapter 23 does allow a party to request a declaratory order, and Mr. Klein didn't go through that proceeding.
It does allow that, but that is not required for a complainant to obtain declaratory relief on their complaint through the filing of their complaint. So I think it's really important that that we recognize that there is a difference between declaratory relief and a petition for a declaratory order. And you know, if you look at the process, as counsel was saying, they're totally distinct and separate processes. A complainant does not need to file a petition for a declaratory order in order to seek declaratory relief in their complaint. That's something that under Chapter 23, the Public Information Board is expressly given the right to do in resolving public records disputes. And a petitioner for a declaratory order before an agency doesn't have to file a complaint. So these are separate processes. And I think that the district court conflated them in finding that he didn't have a right to seek declaratory relief in his judicial review action. But he did, in fact, have a right to do that because he sought declaratory relief in front of the agency below. And I see that I am over time. So Thank you, Your Honor. So I would just ask that this court reverse the district court below and right this ship. It has been 6 years now since Mr. Klein filed his complaint with the Public Information Board. Even when reversed, it's going to be another year, if all things go well, before he's able to get these records. But this delay has been immense and painful to his clients. And so we ask that this court reverse. Thank you.
Versus Iowa Public Information Board et al. Is hereby submitted. The court is going to take a 5-minute recess while the attorneys get ready for the next case, which is State versus Thorin. We'll adjourn for just a few short minutes.